Have you ever wondered what really stops the UK from deporting illegal migrants and asylum seekers? Today, we explore one bold proposition. Unless the UK withdraws from the European Convention on Human Rights, such deportations will remain legally blocked. And with political pressure rising fast, this scenario could unfold sooner than many expect. The UK is bound by the European Convention on Human Rights, enforced by the European Court of Human Rights in Strasbourg. Although this isn't an EU treaty, it is part of the wider Council of Europe framework, and the Human Rights Act 1998 gives it legal force inside the UK. Most deportation challenges are built around two key articles: Article 3, which forbids torture or inhuman treatment, and Article 8, which protects the right to private and family life. In practice, these clauses create serious legal hurdles for the Home Office. The European Court frequently issues emergency injunctions, called interim measures, blocking deportations if they believe the person may face harm. In Uthman v United Kingdom, also known as the Abu Qatada case, the court blocked deportation because the destination country, Jordan, used torture-based evidence in trials. That case, along with others, showed how ECHR decisions can override UK government and court rulings, leaving ministers legally stuck. To work around this, the UK has been rewriting its immigration laws. The Nationality and Borders Act 2022 criminalized illegal entry and allowed authorities to dismiss asylum claims from people who arrived through so-called safe countries. Then came the Illegal Migration Act 2023, which gave ministers powers to detain and remove those who arrive illegally without allowing them to claim asylum. But even that law quickly ran into legal challenges under the ECHR, especially over Article 3 and detention limits. Many legal experts say the ECHR is now the central barrier to enforcing UK immigration law. Barrister Mark Guthrie believes the UK is on a legal collision course with Strasbourg. Professor Ilias Trispiotis explains that Article 3 imposes an absolute ban on removals where serious harm is likely, and that threshold is interpreted broadly. According to Migration Watch UK, ECHR-related legal appeals are one reason why Britain struggles to remove even a small percentage of failed asylum seekers. Still, public frustration is boiling over. The channel crossings continue, hotel bills are rising, and people see the system as broken. In recent reports, UK officials confirmed they are pushing for ECHR reform behind the scenes, especially on interim rulings that block deportations. And behind that pressure is something raw: anger, fear, and exhaustion. The invasion of illegal migrants, especially from countries with very different cultures, laws, and views on gender, has been linked in multiple police reports and studies to rising crime, including violent assaults and sexual offenses. The number of rapes and sexual attacks has spiked in some areas, often with asylum seekers under investigation. These aren't just isolated cases. They're now part of a growing pattern, and the public knows it. Many communities feel overwhelmed. Women feel unsafe. Parents are scared, and patience is running out. But it's not just fear, it's the financial burden too. The UK government is spending hundreds of millions of pounds a year on hotel accommodation, food, clothing, legal aid, healthcare, and even mobile phones for those who entered illegally. And who's paying? British taxpayers, working people, families who can barely afford their own rent. Citizens who follow the law and pay their dues are watching their taxes support those who broke in. The anger is real and it's growing. Many now say clearly they want these illegal arrivals out immediately. Nigel Farage, founder of Reform UK, has called for a full withdrawal from the ECHR, calling it a roadblock to national sovereignty. Richard Tice, Reform UK's current leader, agrees. Suella Braverman, former Home Secretary and now a key figure in the Conservative Party's nationalist wing, said in 2023 that the ECHR was an obstruction to the will of the British people. Even Priti Patel supported a full rethink of Britain's human rights obligations during her time in office. Labour remains officially opposed to leaving the ECHR, but even they have started tightening asylum rules. Yvette Cooper has promoted fast-track reforms and backed policies to limit legal appeals based on Article 8. But here's the truth most won't admit. Border control is no longer possible. Every effort to tighten the system has failed. Patrol boats haven't stopped the crossings. Laws haven't sped up removals. Promises haven't calmed the crisis. And this isn't just a UK problem. France, Germany, Italy, even Australia and the US have all failed to control illegal migration. The forces driving migration, conflict, poverty, global inequality, are bigger than any national policy. And as long as these push factors exist, the flow will continue. Enforcement will always lag behind. This isn't incompetence. It's the nature of a globalized world. You can build barriers, pass laws, and hold press conferences, but the arrivals won't stop. Britain is facing something that no modern government has been able to manage: large-scale, relentless, unstoppable illegal migration. Despite these efforts, the ECHR still binds the UK legally. Strasbourg rulings remain enforceable. Even if British judges approve deportations, the European Court can still stop them. Unless the UK leaves the convention or rewrites its domestic human rights laws, there's no way around it. If Britain does leave the ECHR, it will also leave the Council of Europe. That means no more interim measures, no more Strasbourg appeals. The UK would regain full legal control, but at the cost of international pushback and political fallout. Article 3 and Article 8 would lose legal power at the international level, though the UK would still be bound by UN refugee law and general international standards on non-refoulement. But leaving wouldn't make the UK a pariah. Many respected democracies are not part of the ECHR. The United States is not a signatory, nor are Canada, Australia, or India. These countries manage their own human rights through national law and courts, and their reputations remain strong. Leaving the ECHR does not mean abandoning human rights. It means reclaiming how and where they are defined. This is not about isolation. It's about sovereignty. Now here's the part few want to talk about, but we must. If this conflict between public will and legal barriers continues to escalate, serious unrest is not out of the question. Some analysts warn of a breaking point. We've already seen protests outside migrant hotels, tensions in parliament, community clashes. What happens when people feel they're being ignored? What happens when victims of crime speak out and are silenced? When taxpayers feel punished for following the rules? If courts block enforcement while the streets boil with anger, something will give. Civil disorder is a real risk, not a war in the historical sense, but a wave of chaos, riots, breakdowns in trust, and open resistance. The institutions are out of sync, and when the people and the state split, history teaches us what happens next. So where does that leave us? The UK cannot fully remove illegal migrants and asylum seekers while still bound by the European Convention on Human Rights. That's why leaving the ECHR is now being seriously discussed in government and media circles. Supporters see it as the only way to restore control. What do you think? Should the UK leave the ECHR to regain control? Share your thoughts in the comments, and don't forget to like and subscribe. Thanks for watching.